Hey everyone, welcome to today's video. Today we're looking at one of the most concerning and unpredictable sovereign citizens I've covered so far. And I'm not saying that just for attention. We're heading to Michigan, where this individual shows up in 4 separate court appearances. Each one reveals something new about how serious the situation has become. So let's get started and walk through everything step by step.
Your whole name?
Beneficiary.
Oh, he done this before.
What's his name?
The beneficiary.
Yeah. First name, Mr. Beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm
If so,
gonna recall him. Bring up somebody else. Put him aside. We'll call him at the end. Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission
I ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor.
Your Honor, I've heard people claim they were the trustee of their own estate, and I've even heard some say they were the beneficiary of a personal trust. But I've never seen a sovereign citizen try to say that the judge was actually the one facing the charges. This is a completely new level of confusion. Moments like this really show how far misunderstandings can go when someone doesn't recognize how the legal system actually works.
It is you.
Really?
Yes, Your Honor.
Really?
It is you. That is Kevin Pollard. Yes, Your Honor.
I'm Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right, Mr. Pollard.
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't get that.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout. All right, Beneficiary, I'm going to give you another chance in front of another magistrate.
You know someone is being extremely difficult when it takes 2 magistrates just to get through a single arraignment. And while I did appreciate the first magistrate's efforts, especially when he calmly paused the hearing to regain control, the second magistrate steps in with a very smart approach to keep things moving. Together, they manage to guide the hearing forward, even with all the challenges this individual creates.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate in Chartea. DDC.
Excuse me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera 1, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay, are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard, who is listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Wait, what happened to the last person? I thought he was supposed to be today's main example. But I guess when someone is deeply stuck in their own beliefs, especially the way many sovereign citizens are, things start to get confusing, even for them. It reaches a point where their explanations don't make sense, and everyone starts sounding like a different version of the same story. Moments like this really show how tangled their reasoning can become.
Mr. Pollard, Mr. Pollard, now as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor. Shava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. Court dates are February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. Probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, you should not come over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk.
For a moment.
I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct 1st degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, rubbed her he says. Okay? He said, accidentally is what he's trying to tell us what happened. Connor, the situation is she's told the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 1023-2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tether if he's ever be able to post bond. Thank you.
Normally, I think a $250,000 bond is a little steep, but considering the allegations and this person's past behavior, it seems completely justified. In this case, the amount matches the seriousness of the situation. It's a clear signal that the court is taking everything into account and making sure the rules are enforced appropriately.
Counsel Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not sexually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice, okay? This court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th. January 29th, 2024, 9 o'clock in front of Judge McConigal, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a predator in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConigal. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pre-trial,
Do you wish to talk to the gentleman that's in front of the screen?
Judge.
Okay. Just so for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not fair.
Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you go. Go ahead and do whatever.
You cannot do that.
And yet, they still went ahead with it. Funny how that whole jurisdiction thing works. Before we move on to his bond redetermination hearing, the first magistrate returned and really shook things up a bit with a clever move. It was an unexpected moment that caught everyone's attention and reminded him that the court is in control.
February 2nd, February 8th.
February 2nd, February 8th, bond redetermination Monday.
Of this QV trust account that
Huh? What you say?
All right, the next hearing is his bond redetermination. This type of hearing is automatically available to anyone who has a bond they can't afford. Most people would agree that $250,000 is far beyond what anyone could reasonably pay, and the next judge agrees it's unaffordable. He just doesn't agree with that specific amount. The hearing focuses on adjusting the bond to something more manageable while still ensuring the person shows up for court.
$250 cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously, but it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does. But the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high some type of 10% bond. I think $250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah.
Okay, I'm going to pause here for a moment because I had to do some research on who and what the tribe of Judah is, and honestly, I was surprised by what I found. First, the tribe of Judah was one of the original 12 tribes of Israel, and its members consider themselves Hebrew Israelites. For those who don't know, Hebrew Israelites are groups with very strict religious beliefs, sometimes taking extreme positions in public. The tribe of Judah used to meet in Michigan under the name House of Judah. Their leader, William Lewis, was involved in serious criminal activity. He initially avoided a conviction related to child abuse, but later he was federally convicted under 18 U.S.C. 241 for the involuntary servitude of a minor. That is, child slavery. The details are disturbing, and it reminds us of another case we've covered, showing how dangerous unchecked authority can become.
This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond, We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And Your Honor, with all due respect, the way that the people see this defendant, based on previously being charged, now being charged with another CSC first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everyone.
I completely agree with the prosecutor here, but ultimately, it's not our decision to make. It's up to the judge. And Judge Mecanico is about to make things interesting. She has a way of taking control of the courtroom and making sure everyone understands how serious the situation is. This next moment is definitely worth paying attention to.
See, where we I haven't heard their arguments of counsel. Where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess, an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old. Who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the 15-year-old. Allegedly, she talks to a friend, and they come over, and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there. We have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million. Got him. And that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash. Okay. It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford it.
I understand, but the court finds that Mr. Pollard, it may be some serial action is going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure Mr. Pollard is not able, at least right now to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24th. I mean, you know.
Yeah, it's when, you know, it looks like it wasn't until October 14th of 2023 when the mother called asking, who is this Kevin guy? So that we just kind of got that information, and I'm not sure when the 12-year-old, I'm not sure when all the 12-year-old and the alcohol, when that happened. So it's a lot, Mr. Reagan, and so the timeline may get a little bit jumbled, but it's a lot of kids, teenagers, alcohol, sex, molestation. It's kind of blending, and so, you know, we're here where we are.
Yes, sir.
Right, thank you, Mr. Pollard. You can leave.
It's hard to argue with that logic, but you're welcome to agree or disagree with the judge's decision in the comments. Now we're moving on to the final 2 court appearances. The next judge isn't wasting any time with games or delays. John is about to see that the courtroom is serious, and there's no room for distractions or tricks.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249. I'm standing in for the Attorney of Record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard, have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary.
Beneficiary of what?
Of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
beneficiary of trust.
I'm not coming here as the name. I'm summoned as the state trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will capious him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask it to be set for a preliminary examination, but it sounds like it may be a competency issue. So Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if we can set an exam date, but we could also set Monday as a review date.
Okay, why don't we just do that before we set an exam date?
Okay.
The court will adjourn the probable cause conference. If you're able to find Mr. Pollard, we'll adjourn the probable cause conference to February 5th at 8:30.
Yes, Your Honor.
Find Mr. Pollard, and I will issue a capious for his arrest.
Yes, Your Honor. Thank you.
Now that's how it's handled. If someone refuses to provide their identification, the process is simple. They remain in custody until they comply. His next court appearance happened just a few days later, and somehow, Judge King managed to take things even further. The way the judge handled the situation this time was even more impressive. showing just how firmly the court can maintain order and authority.
Sir, in Wayne County Jail, what's your name?
There you go.
Say your name.
Say your name, sir.
For me,
Yeah.
the beneficiary of the state. I'm here today for the state.
What's your name, sir? I don't know who the beneficiary is.
Excuse me?
What is your name?
I'm coming to appear as the beneficiary of the state, Your Honor.
Okay, forget all that. What did your mom call you? What's she name? I have no idea who you are, sir. Okay, well, you're gonna sit there until I figure out who you are.
I'm not under that jurisdiction to consent to the name, Your Honor. That's appearing under your jurisdiction.
Your case is then, because I'm looking for Mr. Pollard. If you're not Mr. Pollard, then you're not here, and a warrant for your arrest, and you can sit in jail till you rot for all I care.
That's fine, Your Honor, but that's
Deputy, you can remove him. He's not here.
He's not here today because he doesn't exist.
Okay, bye.
The all caps entity.
I'm talking to you. Goodbye.
All right, everyone. That wraps up his court appearances for now. Since this case, he's had a few more hearings before Judge King, during which he finally started identifying himself properly. That led to one of his charges being dropped because the state couldn't secure a conviction without both victims present. One of the victims did appear, but the case was dismissed without prejudice. That said, he's still in custody on a $1 million bond for his other charges. Just a few days ago, Judge Bryant found him competent, which means the legal process is continuing. There's still hope that justice will be served and that this dangerous individual will be removed from the community. If you enjoyed the video, make sure to hit the like button. If you didn't, hit dislike, but don't forget to leave a comment. And subscribe with notifications on so you won't miss any of my future content. I'll see you in the next video.